of why are we talking why do people in kinesiology or people who want to be in sport management or anything related to sport, why is awareness and understanding important? And this goes back to the managerial approach, because contracts are just like all aspects of the law, are ubiquitous within society. We deal with contracts on a daily basis, mindlessly clicking on software licenses and agreements to download things for our iPhone or to upload things, or going to the gym and getting a gym membership. You might be asked to fill out a contract. But in the realm of things like hiring new employees, employee agreements, things involving NCAA athletes, such as letters of intent or financial aid for those who are seeking financial aid at the college level. From a marketing and sales perspective, when you're working to bring in new revenue for your organization, things like ticket agreements, sales agreements, merch agreements, donor agreements, facility lease agreements. Well, actually, that's actually facilities, but selling suites. Again, these are all based in contract, and we'll talk about what that means. Facilities, rental agreements, maintenance agreements, blah, blah, blah. And then governance agreements, which we'll talk about governance later in the semester, constitutions, bylaws, game contracts, CBAs. These are all part of the governance mechanism, but they're based in contract. For those who are got the textbook and are reading it, you can see that different aspects of contract law are illustrated throughout this chapter. We've got issues involving game contracts or coaching contracts or player contracts. We've got elements of just contract law principles, and the words on the right hand side in those columns are all related to different cases that illustrate each point in the textbook. Okay, so let's jump into it here. Let's jump into contract law, because I'm sure you're dying to understand what is a contract and how does it work. Well, don't worry, I'll tell you. But before we can get there, when we're talking about the law of contracts, and just a contract is a promise or a set of promises between two or more people that the law will enforce. So when we're talking about the law enforcing a contract, it's going to be interpreting the contract through this, what the textbook frames as canons of interpretation. Sounds very, very heady, very very Latin here. People just sitting around and trying to interpret what that means. But when the language in the textbook says that the contract is integrated as a whole, but that basically means that when you look at a contract, you read it trying to figure out what is the overarching overall intent of the contract, of what did the parties really mean as a whole. We're not trying to cherry pick different sentences or words or clauses. No, we're not going to do that. Instead, we're going to see what the parties intended from an integrated whole as the entire contract. And as a policy matter, a contract is going to be construed against the party who drafted it in sort of, if you and I are drafting up a contract for you to mow my lawn, and I'm the one actually who writes out the contract and gives it to you, and you sign it, and then there's a problem with that contract, a court is going to automatically say that unless I can prove that I'm not in the wrong, that I will be in the wrong because I had that opportunity to draft the contract and I gave that contract to the person. So it's a policy matter that the person who drafts the contract, unless there's language in the contract that refutes this policy, but the person who drafts the contract is going to be the contract's going to be construed against them. And then secondly, in terms of sort of overall overarching thoughts or themes before we even talk about contracts, it's good to think about a contract and putting into the contract what might happen in the worst case scenario. And although people don't like to think about that, The purpose of a contract is to set out rights and responsibilities between parties to figure out who has to do what or who's responsible for what, especially in the event of the contract is breached or that someone does not do their obligations. So thinking worst case scenario and putting legal effect to that is going to be the best way to use a contract, because that way when you're thinking about the worst case scenario, you've got a set of instructions already agreed upon as to who will do what. Cool stuff. Okay, so what is contract law? Well, simply, contract law is the law of exchange, meaning that someone is going to get something on one side and then the other person will give something up, and then vice versa. That person giving something up will also get something that they want from the other side, and that's the law of exchange. And the purpose of the contract is, in addition to thinking worst case scenario that we've got a plan, but also to make sure that things will always go as expected, that there won't be any surprises. So in terms of the law of exchange, the contract just simply says that one thing is exchanged for another. Money for services, services for products, etc., etc. So we'll look at this first one on the left, money for services. Many of you are taking this course from me. Hopefully you're getting what you expected. Again, we're hoping that there's some for here that the transaction will take place as expected, so no surprises. But you are paying X amount of dollars per credit, and each of those credits are being used to take a class. And this class is either a service or a product, depending on what level of description you want to label these courses. Or, on the flip side, services for money. Look at me. I am doing this class. I've created this class, and I'm lecturing to you in exchange. Surprisingly, I know, and sadly, I know, I'm not doing this simply out of the goodness of my own heart. Although, as I go, I want to tell you that I'm taking this. I became a professor and academic because I want to do good and give back to people who I think I can really make a difference for. So there is some noble sorts of reasoning here, but the other reason is money. I need money to live. So it's services for money. So when I sign my contract with the university, there's certain expectations and obligations I need to do in exchange for them paying me money. So it's the law of exchange. I'm getting something and giving something up, and the university is giving something up, the money, and getting something in my services, just like you are giving money up for the service to get for the service that to take my class, or the product, you could argue, your education. Okay, so again, a contract is a promise or a set of promises between two or more people that the law will enforce. And there's 4 steps to analyzing a contract to see if we've got any sort of legal issue. The first is the formation. Do we have a contract? Second, we need to interpret it. What does the contract mean? Okay, we've got a contract, but what do the parties really mean by what's in that document? And then thirdly, okay, we understand what it means, but are the sides performing? Are they doing what they promised? And if they're not doing what they promised, then we've got a problem and there's a breach, and how will the law help to protect the person who has not breached the contract? So there are, in the realm of contract formation, the essential elements of a contract are offer, acceptance, which is the basis of the contract, of an agreement, and then consideration, and then legality and capacity. And we'll talk about each of those. But basically, the answer to these questions is, have the parties behaved in such a way as to create a legally recognizable expectation? So that basically means you can't just subjectively in your own mind think that you've got a contract. It needs to be objectively manifest by your words and by your actions. Offer, acceptance, consideration, legality, and capacity. Okay, so offer and acceptance. An offer is defined as a promise that's made conditionally by the offeror to the offeree. The offeror is the one making the promise, and the offeree is the one who has the ability to accept the offer by saying either yes or no, or I accept or I reject. So in order for an offer to, under the law, validly exist, there are elements of specificity that must occur. First, the offer must identify the parties who are going to be taking part in the contract. So it needs to identify Jeff in the university, or you folks and the university as customers. The subject matter must be identified. So it can't just be that the two parties are agree to do something. There needs to be specificity here. I, Jeff, will pay Tammy $20 to mow my lawn. Okay, so that's the subject matter. Time and place for the performance. Okay, you will mow my lawn on August 29th at 2 p.m. at my house. Okay, great. There's specificity. And the price or payment terms, I said $20, and I'll give it to you immediately. And then plus any other terms that might be essential to the parties as stipulated as essential. So that might be worked out by the parties and depend on the contract. Okay, so once we've outlined who is identified in the contract, the subject matter, where and at what date and time it's going to occur, what are the payment terms, and anything else that's deemed to be important to the parties, then we can move on to see whether or not an offer actually has been made. The offer, all those elements become the offer, and it vests a person with the power of acceptance. So I've made my offer to Tammy to mow my lawn, and now she's the one that can, oh no, excuse me, sorry about that. She's the one who can actually kick this into a valid contract, at least from an offer and acceptance standpoint. I guess a valid agreement, because in order for there to be a valid contract, there needs to be offer, acceptance, consideration, legality, and capacity. So a valid agreement, Tammy has to say, yes, I accept. All you need to do is show valid assent in a non-ambiguous manner. So when is an offer not an offer? If it's made in jest, you're doing it as a joke, and it's objectively determined that this is a joke. So if you, again, appear to be serious on the outside, but on the inside you're laughing, saying, hee 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 hee, I'm just messing with that person. Like if you say, I'll sell you my 2016 Mustang for $50, and you're just, that's just a joke, but that person objectively, if believes that that's serious, then you got a problem. But, okay. If the offeror is drunk or under the influence of drugs, that affects his ability to appreciate his actions, that's a little bit dicey. Because if the person who's the offeror was involuntarily drugged or under the influence, then that takes away that person's capacity. But if they do it voluntarily, then the offer is still a valid offer so long as the offeree does not realize that this person is drunk, and they've got the power to either accept that or avoid it. Expressions of opinions such as quotes or estimates, like you ever get a quote from the body shop to work on your car, and you take it in and you expect them to be charging you that price, but they actually charge you a higher price at the end. Quotes are an expression of opinion, an estimate, so that quote's not legally binding in most cases. Advertising, invitations to buy. If you've ever seen a used car dealer saying, we'll give you a new car or we'll give you a used car for 50 bucks, or no credit, no problem. These are advertisements. Or if you have someone who's saying, this car drives like a dream, that's puffery. That's just that's just part of advertising, and that's not part of an offer. And then, of course, negotiations. So people are just negotiating, which we learned about in Chapter 3, which is part of alternative dispute resolution at times. Negotiations, trying to get a better deal. That is not an offer. Okay, so now that we've outlined what an offer is, now we can move on to acceptance. So acceptance is just an unequivocal consent that is made by the offeree to the terms of the offeror's offer. So basically that means that in no uncertain terms, the person who has the power of acceptance, the one who's receiving the offer, says, I accept, or something to that effect. You can make acceptance in any way so long as it's clear and unambiguous. So again, it's about what you objectively are displaying. Offers and acceptance should also be made in writing if possible, because that way it shows that it creates a record of the existence of offer, acceptance, and an agreement. And verbal contracts or verbal agreements become more likely to become a he said, she said. And we'll learn later that there are certain types of contracts that must be in writing. Okay, so if you have not said, I accept the offer, an offer can die. It can be terminated by rejection, a counteroffer, the lapse of a certain period of time, usually about 30 days or so, whatever is reasonable under the circumstances, revocation by the offeror. The offeror says, I reject, or I revoke my offer, or by the death or incapacity of either party to the contract. And that's good public policy. So a rejection is fairly straightforward. I don't accept that offer. That's a crap offer. I'm not doing it. Counteroffer says, well, that sounds okay, but I'll actually buy your car. You're offering, you want me to buy your car for $25,000. I'll buy it for $20,000. So that's a counteroffer. And then under that situation, the original offeree now becomes the new offeror, and the original offeror becomes the new offeree with the power of acceptance. Okay, so now we stop and we get to a very important concept of contracts. And in fact, one of your discussion board questions for this week discusses consideration. And in fact, it's tied to the Joey Bosa case that's going on in San Diego. So consideration is just defined as an exchange of value. Basically, one party is getting something, but they're also giving up something, and the other party is doing the same. There needs to be mutuality of that obligation. So again, going back to the example where you're paying for the education at the university, or at Texas A&M University in Corpus Christi, you are paying a set amount of dollars which has value in society, and you're losing that ability to spend that money on something else. But you're gaining something, which is the opportunity to take this class, hopefully get a good grade in the class, and then use that toward getting your degree. Now the university is getting money, again it has value, but it's giving up its ability to give your spot in this class to someone else. Or from a more straightforward standpoint, the university has to pay me to teach the course, so they're also losing value. So both sides have mutual obligation. So let's go back here. Let's go to the discussion boards, because we've got an example of hopefully I've got it up here. All right, yeah, good. I did something right. All right, so we've got an example of consideration right here. Consideration exercise. Hopefully you can see this. So it says define the elements necessary to create a legally valid contract, blah, blah, blah. That's great. That's great. All right. So now we're going to go to this part 2. Read the four statements very carefully, and we're looking at consideration. Which of these meets the rules of consideration? I'll give you my Yankees hat for your birthday. So the question becomes, the offeror is giving something up, but what is the offeree giving up? Versus, say, question 3 here, I'll sell you my Yankees hat for $25. How are these two statements different in terms of having consideration or lacking consideration? So that will be one of your homework assignments, so I'm not going to tell you right now, but I think it helps to illustrate the concept of consideration. If something does not have consideration, it is not a valid contract. If someone says, I will promise to do something for you, but you're not getting anything back in return, or you've got that person is not getting back anything in return, or there's no obligation on the other side, then there is not a valid contract. Now let's also talk about disparity in bargaining power, because that's an issue of consideration. And this kind of goes back to something I should have said during consideration. The purpose of contracts, once again, is to lay out a record of what the sides should be doing in giving up. And then the law enforces that agreement by providing the remedy that either both the parties agreed upon, or that the law has on the books in statutes or in common law. But in terms of considering whether or not there's adequate consideration, that's a mouthful right there, but it's not the court's role to decide whether or not equal value was exchanged, 50%, 50%. So, for example, if I sold you my Michael Jordan signed rookie card for $50, but then I realized, what am I doing? It's worth $1,000 or $5,000, and I say, you know what? Take your money back. I actually want more money. I want that $5,000. And you sue because you had a valid agreement. The court is not going to say, well, it's actually worth $500 or $5,000. This is not a valid contract because it lacks consideration. The court will ask whether or not the positions were reasonable at the time. So as long as both sides are giving something up that is more than just a de minimis amount, and receiving something that's more than just a de minimis minimal amount, then the court will usually validate the contract so long as there's no other issues, because it's not the court's role to determine what is equal value. So under disparity of bargaining power, that basically means that one side has all the bargaining power, and they're offering what's called an arm's length contract, or not arm's what do they call it? They're offering a contract where a take it or leave it contract, that the one side is not going to negotiate. So Walmart is not going to negotiate the price of its television set with you because it has all the bargaining power. If you don't like it, you can just go somewhere else. Or if we talk about the Walmart of college athletics, we can talk about the NCAA. They put out a national letter of intent that universities use between an institution and a student athlete. And the national letter, and none of the universities are going to negotiate individually with that student athlete, even though in theory you could negotiate a contract with a university. But because the university has all the power, they refuse to bargain because they're all acting as one, as a conglomerate. Because of that, the individual student athlete or high school student has no bargaining power. So In the event that there is such a high disparity of bargaining power between the parties, a court may invalidate the contract, but if there is some level of negotiation, then more likely than not, the court will honor the contract for consideration. So, having just said that, and we're talking about National Signing Day, having read about let's say you know about the disparity of bargaining power, what would you take into account before signing the letter? It might be worth, if you try to negotiate, if there was some negotiation, that perhaps the contract is completely enforceable, or perhaps knowing that the other side did not negotiate at all, it's possible that a court might invalidate that contract, but there's no guarantees either way. Okay, so we talked about offer, acceptance, and consideration. Now we're moving on to legality and capacity. So legality, quite simply, is under a contract is not enforceable if the contract is for a subject that's prohibited by law. Things like gambling and prostitution in most jurisdictions are illegal. So if there's a contract covering any sort of topic that's illegal, then it's going to be deemed invalid. Now, an interesting thing to highlight here is the covenant not to compete, which is an agreement or an element of a contract that's negotiated between parties, usually an employer and an employee, that says when the employee stops working for the company, that he or she will not work for a competitor for a certain period of time, or that the employee will not work in a specific industry for a certain period of time. Now, under the law, the more restrictive that covenant is, and the more limitations that are placed on that employee that prevent him or her from pursuing their livelihood, the more likely it will be deemed as illegal because it's against public policy. So that's something to think about. And then finally, capacity. Any sort of mental infirmity or something that prevents someone from knowing the nature and quality of their actions means that they're legally incompetent. Further, minors, or someone who's below the age of 18, which is the age of majority in most states, they are deemed to be mentally incompetent. Again, this is a public policy matter. Why do you guys think that someone below the age of 18 is mentally incompetent and must have their parent contract, or their parent or legal guardian contract on their behalf? Right, because it's public policy that people who are below the age of 18 are still getting their bearings about the world and getting their education, are still developing. So it's unfair to put them in a position where they would be personally responsible for their actions in terms of contracts, because they might not know any better. And then we'll talk about later in the course of the concept of agency law, and how the realm of agency law can impact elements of capacity. Okay, so let's follow up the concept of legality with an example here. Athletes first negotiates the football coach's record-setting contract that includes the clause, if coach resigns from the University of Texas at Austin, he cannot coach any other Division I football team. Now remember, the more restrictive the language in that contract is, the more likely it will be deemed void because it's illegal against public policy. But let's start off at a baseline that the parties are free to negotiate anything they want, so long as they come to an agreement and the topic is not illegal, both sides have capacity, there's consideration, there's valid offer and acceptance. So here, within this element, we don't know what the consideration might be, but let's talk about that, and let's leave that alone for now. In terms of restrictive covenants, we look at three different aspects: the subject matter, the geographic area, as well as industry segment, and the time. So the subject matter here asks how restrictive is the language in terms of the type of activity. Here, the coach is going to be restricted from coaching any Division I football team. So the coach can still coach Division II, Division III, professional, high school, rec league. The coach can coach anything other than football. So there is a level of restrictiveness, but there's also alternatives. Now, the problem here is that area and time are very restrictive. Area is sucked up in the insinuation that because that coach cannot coach any other football team and there's no time modifier, we might be left to believe that that time modifier means it's forever, so it doesn't matter what area. Now this clause is also somewhat ambiguous, so we can come back to interpreting this very shortly, like right here. So let's say that we have a valid contract. The contract has been formed. There's offer, acceptance, consideration, legality, and capacity. But now we need to understand, what do the parties mean? What is the words and the sentences and the paragraphs add up to? And to help us with that and understand what are the legal expectations, obligations, etc., we need to look at these different mechanisms that will help with interpreting the contract. So the first element is the Perl evidence rule, and which goes hand in hand with integration clauses. So the Perl evidence rule, which is used to interpret contracts, basically says once a contract is put in writing, it supplants, it takes the place of any other agreement or understanding that the parties had previously made verbally. And if it's, once signed, the most recent contract between the parties will govern. So it will also replace any older written contracts. So once there's a written contract that's executed means signed by both the parties. So once the contract is signed by the parties, it cannot be challenged unless the contract is ambiguous or inconsistent. Maybe there's language in there that could be interpreted several different ways, or maybe there's language that's incomplete. So, for example, back to this restrictive covenant, it says if coach resigns from the University of Texas at Austin, he cannot coach any other Division I football team. Well, does that mean that it's forever, or if it's for a specific period of time? So the coach that is curious, wants to challenge that, might say, well, we don't know what the time element was because it was left out, and was that done on purpose or was that done by accident? So here, if the language in the contract can be interpreted as being ambiguous or inconsistent, then new evidence can be admitted in court to try to explain any of the ambiguous terms. But if the contract is not ambiguous, then it cannot be challenged, and the only evidence that can be and no evidence can be admitted that alters or contradicts the terms. It can only be interpreted by what's written in the contract. So that would be both the Perl evidence rule and integration clause. Integration clause just means that there's language within the contract that says that this contract is the final understanding and agreement between the parties. So let's see if I can bring that up here. Bear with me for 1 second here. Not technical difficulties per se. Actually, what I will do to be cool is we will go to the content here. So if we click on a contract, so let's look at this contract between the University of Michigan. Hopefully it doesn't take forever to load up. Hooray! And the University of Michigan or the contract between Nike and the University of Michigan. You can see it says executed version right down there. So the parties, both Michigan's athletic department and Nike, have signed off on it. So let me see if I can find the language I'm looking for about an integration clause. It's usually under general general terms. Kinds of products, that's not helpful, that's not helpful. Right to set off. Set off, well, it's part of the Joey Bosa assignment. Rules. Long contract, rights for new contracts. Termination. Post-termination. Alright, notices, remedies. We're getting close. Oh, we're getting close. Confidentiality. Entire agreement. Alright, here's the integration clause. It's right at the end. The integration clause here is under Section 35, entire contract. As of the execution date thereof, this agreement shall constitute the entire understanding between the university and Nike and may not be altered or modified except by a written agreement signed by both parties. Any previous agreements between the university and Nike shall have no further effect. And down here we've got all the cool kids signing off on the contract. So if we go back to this language here. The integration clause was that entire agreement paragraph, and it says that nothing else this written contract supersedes and supplants anything else that the parties have done in the past, and that it's the final written understanding of the parties' intent. So the only way to challenge this contract now in court would be to show that it's that contract in some way, shape, or form written together is ambiguous, and that new evidence would clear up that sort of misunderstanding. Okay, next is statute of frauds. And statute of frauds is a law that's on the books in every state that says that any certain types of contracts must be in writing in order to be enforceable. And so we've got contracts for the sale of real estate, contracts for the sale of goods over $500, and contracts not to be performed within 1 year. The contracts that take more than 1 year to perform must be written out. And this is done for the simple public policy reason that contracts involving real estate or for things that cost more than $500 or something that cannot be performed within 1 year are usually complicated tasks, or people forget what they intended. And by, again, writing it out and signing it, it creates a sort of script that shows what the parties actually were intending. And so it's good public policy. Does not become a he said, she said. Okay, so we've got more stuff on integration clauses. So sorry about that, but yeah, here's the example from an example clause. Ambiguity exception, we talked about that. Great. All right, so here is a fun little example here. I love this example. This is a real example. So there was a contract that was signed between the University of Louisville and Duke University for them to do a home and home series. I think it was Duke came to Louisville, and then Louisville was going to go to Duke. And long story short, it said that if one team canceled the contract and the other team could not reschedule that contest with a team of similar stature, then the one who canceled it, who violated the contract, would pay the non-breaching party, the home team, a liquidated damages amount of $150,000. So what ended up happening was Duke backed out of the contract, and this was back in the mid-2000s. And Louisville claimed Louisville had scheduled like Jacksonville State as the replacement team, and they had the game. But then Louisville sued Duke because they claimed that Duke was not a team of, or that Jacksonville State was not a team of similar stature. And so Duke actually said that that Jacksonville State was a team of similar stature, and so there was a disagreement, an argument in terms of what the phrase "similar stature" meant, and that was ambiguous. So new evidence was able to be introduced. So Louisville said that that similar stature was about the conference and with the type of school, whereas as you can see here, Duke was actually saying, well, it's about how many games had the team won, or how many games the team had won. And so here is footage of the Duke University's lawyer on how they interpreted similar stature and why Jacksonville State was a team of similar stature to Duke. If it ever plays.
I think the court can absolutely positively take judicial notice that Duke is probably the worst football team in Division I football. Everybody knows that. That's no secret. The longest losing streak, the inability to ever win games, everybody knows about it. That's well documented. We certainly don't have to go out and take 6 months of discovery to establish that for you. So the bottom line is, how much discovery, if any, should anyone have to take, want to take, or need to take to make the simple analysis of whether or not that was a team of similar stature? It's judicial notice that they got beat by Utah. Maybe that's part of the dispute, is that they wish they'd played somebody weaker like Duke, which would have been an automatic W. I think, again, you can take judicial notice of the fact that the Louisville-Utah game ended up on TV. I don't know, I don't have the discovery on it, but I'll guarantee they made more money playing a team that there was some interest in Utah than they ever would have in playing Duke, who no one would televise in their right mind.
All right. So maybe I got a couple of facts wrong. I think one of the teams was Jacksonville State that Louisville had scheduled, but I think it was that Louisville had went to Duke, and then Duke was supposed to play two home games at Louisville, and so they walked away from those two games, and so one of the teams that they played was Utah. They lost. And that game was televised. But in any case, similar stature, as argued by Duke, was not, what conference or division the other school was in, but instead it was how many games that team had won. And so Duke said, well, anyone is a team of similar stature because Duke doesn't win games. So it's just a way to show that there's a discrepancy in interpreting the contract. Another example of being careful about what the contract means has to do with Richard Mendenhall, who was the spokesperson for Haynes, and he got into some hot water because he had these several tweets on the right where after Osama bin Laden had been killed and it went public, he tweeted some things that were critical about people celebrating the fact that he had been killed, and then he also questioned the legitimacy of 9/11. And Richard Mendenhall, his contract was terminated unilaterally by Haynes because of this language here that said that Haynes Brands had the right to terminate the contract, the sponsorship endorsement agreement with Mendenhall, and no longer pay him if something occurred where it was any situation or occurrence that brought Mendenhall into public disrepute, contempt, scandal, or ridicule, or tending to shock, insult, or offend the majority of the consuming public. So Haynes Brands summarily terminated the contract with Mendenhall, but they never provided any evidence showing that Mendenhall had been brought into disrepute, contempt, scandal, or ridicule, which, although these are lots of words with similar meanings, but there was no evidence. And because there was no evidence that preceded them terminating the contract, Mendenhall actually was able to sue and recover money from Haynes Brands because of their breach. So again, that's interesting because there was an issue about interpreting the contract. Okay. So now that we've talked about formation and interpretation, now we're going to talk about breach. And trust me, we're getting close to the home stretch here. Breach is a failure to perform the agreement as promised. So if one side has actually done what they're supposed to do, they faithfully perform their actions, but the other party has not performed the contract obligations, then there is a breach. So once there's a breach, the other side has not performed, and there's different remedies that come into play. Remedies can come in the form of damages, which is just money. And there's different types of money damages: expectation damages, reliance damages, and restitution damages. And each of them serve a different role in society. Expectation damages puts the party in a position to what they would have gotten had the contract been performed. Let's say that they were supposed to make $5,000 by having some sort of performer come and do a concert. So that would be their lost damages would be $5,000. Reliance damages puts the person in the position that they were in prior to the contract and reimburses them for losses they suffered on the belief that the contract was going to be or that both sides were going to abide by their performance obligations. So let's say that with going back to the concert example, that the promoter had secured a venue and paid a $1,000 security deposit, which is non-refundable. So that would be reliance damages. And restitution damages restores the party to any benefit he has conferred on the breaching party. So let's say that performer, in addition to he was going to get $5,000, that performer also required some sort of non-refundable limousine service. So the promoter spent $500 on limousine services. That would be restitution damages. But there's also something called non-monetary remedies, and that would be situations where money is not enough. And we remember from Chapter 3, there's different types of courts: criminal court, civil court, and the court of equity. Court of equity is the type of traditionally traditionally a court could only grant money damages, and so there would be a separate court of the court of equity or chancery that would grant non-monetary relief. But today, the courts are able to grant both money damages and equitable relief. So rescission cancels the contract and restores the parties to where they were before the contract was actually executed. So Sims versus Argovitz. Billy Sims was a famous Detroit Lions running back. Jerry Argovitz was his agent. Argovitz, unbeknownst to Sims, became a part owner in a football team that was a rival to the NFL. And so during negotiations with the Lions, between Sims and the Lions, Argovitz secretly wanted to get Sims to play for his new team in the rival league because it would create a buzz, and he would Argovitz would directly benefit by the money Sims brought in. But Sims and Argovitz intentionally tanked the negotiations with the Lions and told Argovitz a bunch of lies to get Sims upset with the Lions and not wanting to play. Ultimately, Sims did sign with the team that Argovitz was an owner of, but once all this came out, Sims sued, and the court granted rescission of the contract between Sims and the rival or the rival football team, among other remedies. Equitable relief, again, is a situation where money is not enough. Things like specific performance or injunctions, where a court forces the other side to either do something or refrain from something. That's an example of equitable relief. So we've got Hope Solo, who's in the news recently, who's been suspended 6 months from soccer because she made critical comments. If you have a soccer team who's who signs Hope Solo, and let's say that the soccer federation that suspended her has jurisdiction over the team that signed her, that soccer team could potentially go and sue both the soccer team and Hope Solo, saying that the court needs to issue an injunction enforcing that ban because money damages is not going, fining Solo and allowing her to play is not going to meet the remedy that the soccer federation was asking for. In addition, we've seen examples of Native American tribes suing different NCAA organizations because they are using the names of that tribe without their consent. Again, money is speculative to try to quantify what the unauthorized use of those names would be. Instead, those tribes want them to stop using their names, and so they would go to court to get that injunction. Liquidated damages is something that we're going to be talking about in the next section. It's not a penalty. Instead, it's a clause in the contract that says when certain situations happen that could injure one of the parties, the party that was not breached will be owed a certain amount of money. So buyout clauses, or what happened in the Louisville game, where Duke and Louisville said if either party doesn't, opts out of this agreement, the party who opted out will pay $150,000 to the party who wanted to stay for each time for each game that they did not go through with. And then we've got injunctions, which I talked about, which is a court actually telling the offending party that you must refrain from doing something or that you must do something. There are 4 criteria, and it all adds up to whether or not money damages could actually compensate the party that's asking for the injunction. We won't talk about injunctions all that much, and since we're really far on time, I'll stop it here. Next lecture will be on coaching contracts. So we'll bring back liquidated damages and injunctions, and that will be a fun or a fun lecture as well. So hopefully this wasn't too bad. I know this was pretty long, so I apologize for that. But I will see everyone next class. And again, feel free to email or come by my office hours if you have any questions or want to say hi.